Thank you.
SJC-11049, Commonwealth versus Tassinari.
All right, let's proceed. Yes, sir.
Good morning, Chief Justice Ireland, and may it please the Court. My name is Robert Shaw. I'm privileged to appear today on behalf of John Tassinari. I want to begin today by acknowledging where there is agreement in this case. It is agreed that this case involves an episode of extreme and horrific violence. A wife, a mother, shot 18 times by her husband, by the father of her son, by the father in the household. It is agreed that John Tassinari's actions cannot be justified and they can't be excused. Notwithstanding that overwhelming evidence of guilt for having taken Barbara Tassinari's life, I suggest to this Court that this case presents a very close issue with respect to state of mind and whether this violence arose out of the heat of passion, the sudden loss of control upon the disclosure of infidelity. Now, there are many issues in this case, and I intend to address several, but with a discrete focus on what I think is most useful given what's in the briefs, and I'll begin with the government's assertion that Mr. Tassinari was not entitled to a manslaughter instruction. I have two basic points on this issue. The first is that the Commonwealth's argument is not true to the record. There was no suggestion in this evidence that John Tassinari believed or suspected that his wife was actually being unfaithful and that an affair was taking place.
Well, hold on now. Just in terms of the facts, hadn't they discussed an open marriage relationship long before this event occurred?
That's correct, Your Honor. And what's very important is for the Court to look at the dialogue and the progression of communication that occurred between the two, because this was something that was raised by Barbara Tassinari. It was discussed, it was talked about, and there was a decision that the marital vows would remain and that monogamy would remain. And there was an effort to continue the marriage, to try to save the marriage, and that is quite clear in the electronic communication between the two. This was real-time communication, very unusual in a case like this, where you can see exactly what they were talking about and the state of mind of each. So that progression is very, very important. And I would note with respect to manslaughter that evidence at all levels in this case really is consistent with the sudden loss of control. We have an absence of planning. There's no history of criminality in Mr. Tassinari consistent with a plan to kill his wife. There's no history of violence in this relationship. This shooting occurred under floodlights in the midst of a neighborhood's awareness. The guns were dropped out in the open. Now, my second point is that the Commonwealth's argument is really not true to the law. The evidence needs to be viewed in a light most favorable to Mr. Tassinari. It is not adequate to say, now I'm going to review evidence from defense witnesses and the real-time communication between the parties, and then spin that evidence in a manner that is heavily favored to the Commonwealth. And respectfully, I suggest that that's what's happened here.
Was there, I saw a reference, I think, in the Commonwealth's brief, quoting Judge Locke about never being reversed if you give it. Was there much discussion about whether manslaughter was or wasn't raised by the evidence?
My interpretation of that exchange, Your Honor, is that Judge Locke was sort of challenging the prosecutor on this. It was by no means saying, well, I might as well give it because I don't want to get reversed. I addressed that in my reply brief. There wasn't a lot of discussion. Judge Locke said, if you are going to suggest that he's not entitled to a manslaughter instruction, I want to see cases. As I understand it, and based on the record, nothing was provided by the prosecution. I also want to note that the law does not say that there cannot be an inkling of marital discord for there to be the sudden and shocking disclosure of infidelity. It doesn't say that there can't be some jealousy, that there can't be contemplation of separation. Human relationships just aren't like that, and we don't require that there be a perfect marriage and a white picket fence and then all of a sudden a disclosure of infidelity for there to be a sudden and shocking disclosure. So again, I would focus on the progression of events and the dialogue between the parties.
Does it make any difference that there was a sudden disclosure in wake of, or in the wake of, ongoing suspicion?
I don't think so, Your Honor, because, you know, I think that the record is not sufficient to conclude that there was some ongoing one-pointed suspicion that there was an affair taking place. There was trouble in this marriage. There was discussion about that. There was an effort to save it. There was talking about it. John Tassinari was obviously somewhat tormented by the notion that his wife raised the issue for discussion about an open marriage. But that is by no means the suspicion of an affair. There was concern in this marriage. There was a lot of emotion, a lot of ups and downs. But I do not think.
Well, there were her relations with the men who were involved with the dogs.
Right.
He was aware of that.
Yeah, and that was not in itself an issue. The issue that occurred was the fact that she was always on her computer, but it really didn't surround the fact that she had these dog friends, so to speak.
Well, but the dog friends plus then the alcohol, excess alcohol consumption, so you add that together. I thought his concern was not so much about the men, but that she might not be able, that they might take advantage of her.
On this trip that she was going to take,
Yes.
That's correct. And again, that is not suspicion of an affair. So if you look at the cases cited by the Commonwealth and addressed in my reply brief, you will see that in those cases there was either the belief or knowledge, really the awareness that there was an affair taking place or some other relationship taking place. That does not exist in this case. Now, with respect to the provocation instruction, my basic point to the court is that it is nonsensical for an instruction to say that mere words standing alone cannot constitute provocation, and then to say that mere words standing alone can constitute provocation if they are a certain kind of mere words.
Information
Yeah.
can constitute provocation, but me swearing at you or calling you names cannot. But the information is conveyed by words, of course, or it can be conveyed by observations. Isn't it the instruction pretty clear on that?
I don't think it is, Your Honor, and I think that you have to look at how a jury might latch on to the statement that, quote, mere words, no matter how insulting or abusive, and many things can be insulting or abusive, factual information can be insulting and abusive, standing alone do not constitute reasonable provocation. Mere words standing alone do not constitute provocation. That is incorrect. Words are words. If you've got words and that's all you've got, that's what you've got. The instruction should just focus on the subject matter of words.
However, the existence of sufficient provocation is not foreclosed because a defendant learns of a fact from a statement. If the information conveyed is of a nature to cause a reasonable person to lose his or her self-control, what's confusing about that?
Well, because it is first making a pretty absolute statement that mere words standing alone can't constitute provocation. I do agree that when you go on and read it, it now provides conflicting information. So that's the first problem with the instruction. And I suggest to the court that there's really no reason for that. There's no reason for the court to endorse an instruction that does that. Now, the other problem, which you mentioned by reciting that, is the fact that the instruction actually then says that if it is going to be sufficient for provocation, then a factual event that happened
No, it doesn't
must
say
be
that
conveyed.
happened. It says, it doesn't. It says just a fact. It doesn't say it has to be true.
Well, Your Honor, the language is that the defendant, quote, learns of a fact
Yeah.
Not receives information or an allegation, but learns of a fact from a statement rather than personal observation. So it's holding the two together. If you say, well, you're learning of a fact by words rather than personal observation, the implication of that is that it is something that occurred. You didn't see it, even though you could have. Okay? So I think the question is, why would we want that in our instruction? That's very confusing. It's contrary to the law. There's nothing in our law that says that an event must have occurred, that it must be factual. And you
I
must...
don't remember this, but have you looked at the new homicide instructions?
Yes, I have.
And is it the same?
It is the same, Your
It is
Honor.
the
It is the same. So I would urge the court to look closely at this. I don't think it would require that much of a change, but certainly I think that this is really it's not a clear instruction, and I think it was highly prejudicial to Mr. Tassinari, especially where defense counsel conceded, or I shouldn't say conceded, he indicated to the jury that he was not trying to say to them that an affair had actually occurred. He was focused on the disclosure, but under the terms of this instruction, if the jury was supposed to determine that a fact occurred, that there was something that occurred that was factual through words rather than personal observation, that's very prejudicial to him. Now, the second jury instruction issue concerns the fact that the instructions were structurally biased in favor of a finding of murder rather than manslaughter. And the reason for that is that the instructions repeatedly stated elements that compelled the jury to arrive at a conclusion of murder without mentioning the essential requirement that the government disprove mitigation beyond a reasonable doubt. Judge Locke mentioned the notion of manslaughter at the beginning of the instruction. He did not set forth a requirement that the government disprove mitigation. And then at least 7 times when you read those instructions, when he instructs on first degree, deliberate premeditation, extreme atrocity and cruelty, and then second degree, he sets forth elements. If you find elements A, B, and C, then you should find the defendant guilty of murder. And he doesn't recite the essential element of manslaughter. In analyzing this instruction, I'm asking the court to acknowledge, or at least be informed by, what I would suggest is the unstated but self-evident fact that when a judge sits down for more than an hour to recite complicated principles of law to folks who are hearing them for the first time, comprehension is extremely low.
Was the either the tape or a copy of the instructions given to the jury?
A copy of the instructions was given to the jury, and I would suggest to the court, as has been evidenced by certain studies that I've cited, that a jury, as one would imagine, will go back to the jury room, take the instructions, and follow them. And that is precisely what the problem is here, is that if that jury took those written instructions and followed them step by step, they would have concluded he was guilty of murder without ever reaching the issue of manslaughter, because the instructions repeatedly told them that if you find these elements, then you must conclude that he is guilty of murder. I consider this to be, really very significant, and I would ask the court to look at it. If you look at the new homicide instructions, you will see that it has been dealt with. Now, there is also a juror issue in this case, and it involves not only a deliberating juror who was not a United States citizen, but the judge overruling the defense objections to striking the juror and putting on an alternate. And the judge made findings, which I suggest were unsupported by the record and were not informed by the law. This issue was raised by the juror, not the defense. And the juror admitted that he was born in Canada. He admitted that he was never naturalized. He characterized his status as a gray area, and he cited something called, he referred to it as the J status treaty, as giving him some sort of what he thought was dual citizenship. Now, his comments were conflicting in any event, but he used the word dual citizenship. Part of the problem here, which
He also said he had voted, didn't he?
he did, he didn't say whether it was in a federal election or a local election. I think that some non-citizens can vote in very local elections, and there's nothing wrong with that. Certainly, it's a violation of the law if it's a federal election. The judge wasn't asking very probative questions of this individual, I would suggest. I think one of the main problems here is that the judge did not bother to even look at what the Jay Treaty provides. And that is a real problem. He's making findings, he's sending this juror back into the jury room, and he isn't even looking at what the law says. The Jay Treaty of 1794 between the United States and Great Britain.
Was it on his bookshelf behind him?
No, it certainly wasn't, Your Honor, but it's a good thing that everyone has internet access now.
Did he give defense counsel an opportunity to research the matter in the interim and then report back?
I think that's a very important point, and the thing that I would key in on is the fact that it was not an opportunity. And frankly, I think that it really is quite distasteful for a judge to say, I'm going to make findings. I'm going to send this juror back in to deliberate. I'm going to overrule your objection, but by the way, if you can prove that I've made a mistake, let me know.
How long did it take after that for the jury to return a verdict?
Before lunch, they had gone into the jury room at about 9:15, I believe. The only deliberations that had taken place at that point were 45 minutes the day before, so it would have been very easy to put an alternate juror on.
No, Mike, how much time lapsed between the time that this juror came forward and said that he was a Micmac?
I think it was
Native
about 2
American.
hours and 45 minutes.
Okay. And defense counsel didn't report back to the judge with the results of any research that he had been able to accomplish?
He did not.
Okay.
But, you know, the juror had already been sent back in to deliberate.
Yeah, but,
Well, you could-
I mean, you could start again.
And, you know, and this was in Brockton. I know that the defense counsel's office was not in Brockton, so I don't know exactly what the scheduling was or whether he was able to call to try to get somebody to look into it, but certainly they came back very, very quickly. And again, the problem here is that we know that this individual was not a United States citizen now. And it would have been very easy to confirm.
What's the prejudice?
Well, I think there's several elements of prejudice. The first is the fact that the juror did not disclose this information during jury selection. The procedures that we have for selecting a jury, the defense could not utilize those because he omitted this. And I think based on the totality of the circumstances, it's fairly clear that he knew there was an issue with his status. He just didn't mark that he was a United States citizen, and he did not respond accurately to his summons when it says very clearly, as I've noted in the briefs, that you have to be a United States citizen. Then there is prejudice that results from the judge having overruled defense counsel's objection, not striking the juror. Again, this is depriving the defense of an opportunity to choose the jurors that he wants. If you look at the cases I've cited, that is a factor in determining prejudice.
Is there any indication that the jury's verdict was not fair and just because this person was improperly placed on the jury?
Well, I think it's much like a public trial issue, Your Honor. I think it would. It's very structural in
But
nature.
the statute, Chapter 234A, Section 74, requires you to make a showing of special prejudice, doesn't it?
Well, and I think I'm doing that. And I think that when one looks at the principle.
But the statute presumes all these technical defects have occurred, just as you've described. But now it asks you to show what prejudice has flowed as a result of a person having been improperly placed on a jury.
Right. And I think that there is prejudice for the reasons I've indicated, the defense being deprived of an opportunity to use the jury selection process. And, you know, alienage is a suspect classification. This court has determined in Commonwealth versus Asen, consistent with federal courts, that there is a compelling interest to exclude non-citizens from jury service.
But it's a statutory interest. It's not a constitutional question.
Well,
I mean, this is not a constitutional question. We're not talking about a structural error in a constitutional sense.
well, I'm just pointing out that there is a compelling interest to not treat non-citizens equally when it comes to jury service.
Well, he'd been in the country 50-some years, living as a resident.
Well, we really don't know because of the lack of probing questions what that means. I mean, did he have a place here? Was he here summers? We just don't know. We just don't know. But I think that if there is a compelling interest, it's very difficult to
What's the
say
compelling
that
interest?
there's no prejudice. In order to discriminate and say that non-citizens can't serve on juries, there needs to be a compelling state interest.
What
and
is
this,
it?
And this court has determined, because it's very important that somebody who's going to serve on a jury is integrated into the community and has certain loyalty and adherence to this country and the state. I think you'll see that when you look at the cases that I've cited. And in closing, looks like I'm running out of time, but I think there is a lot of issues, the firearms evidence, the sexual interest and practices evidence, that I would characterize as really prosecutorial excess here. I would ask the court to look very closely at those in the briefs. I think there was no reason for them, and I think that their presence in this case was highly prejudicial.
Thank you, counsel.
Thank you. No, the
Not quite
clock's
yet.
not working. Thank you. Good morning.
Good morning. Mary Lee, Assistant District Attorney from the Plymouth District for the Commonwealth. May it please the court, I'd like to begin where my brother left off with the issue of the Native American juror. You'll find this in transcript 10, and I agree with my brother, there were 2 hours and 45 minutes during which counsel could have gotten some case law and come back to the judge. There's a law library in the Brockton Superior Court. But
And
it
as
didn't-
we've been told, the internet, well, is there internet in the Brockton Superior Court?
I haven't used it recently, but the last time I checked, there was internet access in the Brockton Superior Court Law Library. At any rate, he did not come back with anything for the judge on the GA Treaty during that time period. I disagree with my brother on his statement that we now know that this person is not a United States citizen. The GA Treaty conveys permanent residency, yes, but as I pointed out in my brief, if a person's parents were United States citizens and met certain residency requirements, then their child born in Canada would be a citizen, and we don't know anything about his parental status. So we don't know if he is, as he says, a U.S. citizen having dual citizenship in the United States and Canada, or whether he's just a Canadian citizen and a permanent resident under the GA Treaty in the United States. And so for that reason alone, this court cannot reverse this case saying he's not a citizen. We don't know whether he's a citizen or not, and that's the purpose of my analysis in my brief. But most significantly, under Chapter 234, Section 74, it requires the defendant to make a showing of prejudice even after he has made an objection. And I would suggest to the court that he cannot do that in this case in these specific circumstances, primarily because this juror believes he's a U.S. citizen. And it was his statement that he had dual citizenship as a U.S. citizen and a Canadian citizen that led the judge to reach the conclusion, well, he's a U.S. citizen with a constitutional right to sit as a juror. And in addition to that, in this particular case, the defendant cannot show any prejudice because the juror testified to the judge or said to the judge during their colloquy that he had lived here for 50 years, that he had voted in the electoral system, that he had been here since he was a child. And if you hearken back to the first day of trial, when you're looking at juror questioning to determine whether someone is indifferent, that same juror actually described his experience with the criminal justice system. He had a grandson who he had bailed out and then had kind of walked him through the process. So this is actually a juror who fully participates in the electoral process, who believes he's a United States citizen, who is familiar with not only the United States, but Plymouth County, because he's lived here for 50 years. He's ideally suited to be a juror, and I would suggest, given the constitutional right to be a juror, as well as the statutory right to be a juror, focused against the defendant's statutory right that requires a showing of prejudice if someone is not a U.S. citizen, and that there is no constitutional right, and this is not a structural error issue at all. There is nothing in the Constitution that prohibits the states from permitting non-citizens on jurors. And I would suggest in this case, we have a statute that prohibits it, and the statute requires the defendant to show prejudice. Certainly in these circumstances, the defendant has not made any showing of prejudice, or even that the person is not actually a U.S. citizen. So I would ask that that issue be found in the Commonwealth's favor. I'd like to move to an issue that the defendant, through his counsel today, did not have an opportunity to discuss fully, which is the guns, the lawful possession and ownership of guns. The defendant owned 7 guns that were in his gun case, which was open. You know, according to the defendant's story on manslaughter that he testified to, is that he was about to put his carry gun that he carries with him all the time, even though he's wearing like elastic waistband shorts. It's his .45 caliber Glock, and he's about to put that away. So he has pressed the 5 buttons on his gun safe and opened it. And before him is the menu of his guns. And he has the .357, the .44, the .40 caliber Glock. His .45 is still on his waistband, and then there are there's an assault rifle, which is the AR-15. There's a .22 caliber rifle in the back. So he's got the rifles in the back, he's got the rifles and the guns, and that's what's before him. When he says that the victim came in and said, "Fine, I've been having an affair all along, I've never loved you, I just needed you." And that's the statement that came through the parents and the defendant, and he told the police as well. And the prosecutor wanted to show that menu of weapons to show that the defendant was making a deliberate choice. And it is his intent, and it goes to deliberate premeditation. And counsel has pointed out, particularly in his reply brief, well, what about this assault rifle, this AR-15, which the Commonwealth in its brief refers to as a .22 caliber rifle. It's .22 caliber, so it's a lesser caliber, which was primarily what the Commonwealth was arguing. He used the .40 and the .45. They both have 13 rounds in them. They're without being reloaded. They have hollow point bullets. They're going to do a lot of damage. And counsel is saying, well, that's not a good inference because this AR-15 is in there, and that can do a lot of damage. But I would suggest you look at the defendant's testimony as well as the testimony of Sergeant Force of the Abington Police Department, and you'll see that the defendant kept his rifles unloaded. So that AR-15 was unloaded, but he keeps his carry guns loaded. So I would point to transcript 5, 109 to 110. That's Sergeant Force who described the open gun safe with the unloaded rifles and all the loaded carry guns. And of course the .40 and the .45 are outside on the driveway empty. And then you have the transcript 8, page 138, which is the defendant's testimony saying, my carry guns were loaded, my rifles were unloaded. And transcript 9, page 80, he references that as well. So here we have a person who is making a choice. Which gun will I use to kill my wife for what she has said? As opposed to his testimony that I just remember reaching into the safe and then I'm standing out over her, I feel sick, and I drop the gun. So that's the differing testimony. And the Commonwealth's argument was, this is a man who's certified by the state police, he's licensed, he's got his FID card, he has his NRA card, he knows what he's doing with guns, he trains other people with guns. And he uses the most powerful weapons, the .40 and .45 calibers that have 13 rounds apiece as opposed to the .44, which only has 6 rounds. And those .40 and .45 calibers have hollow point bullets. And the significance of hollow point bullets was in Trooper Arnold's testimony that they open up and cause a lot of damage.
Can I ask you, the case was tried both on premeditation and extreme atrocity and cruelty?
Yes, and the jury returned both.
To return both?
Yes. And so that actually doubles back into the autopsy photos. Now, this is a discretionary standard with the judge, and the judge felt that that evidence was admissible on deliberate premeditation and as well as extreme atrocity and cruelty for the jury to see those. He kept some of them out. Like, he did his job. He looked at the pictures, and he let some in, and he kept some out. The defendant is arguing 3 particular pictures that show brain matter, et cetera. I would suggest the jury needed to see that. They needed to see the amount of damage that was done, because what we have here, and you see in the testimony of the waitress from Deanne's who was on a smoking break and could see the entire back porch, the defendant comes out, he's shooting, there's a pause, there's a scream, there's shooting, he goes back in, comes back out, there's more shooting. The .40 caliber are at the deck, inside the gate, which would indicate that was the first gun used. That's not his carry gun, that's one from the safe, according to his own testimony. And the .45, which he says is his carry gun, the Commonwealth's witness, Frank Scalaro, the victim's brother, testified his carry gun was a .357, so there was a factual dispute there for the jury. At any rate, even at his own testimony, the .45 is the second one used. He goes in, shuts off the lights, and the house comes back out. There's more shooting. Those .45s, the shell casings, are all around the victim, where literally her head is blown apart. And I concede that is what the photographs show at the scene. There's brain matter on the driveway. You see that in the testimony of Sergeant Force. There's brain matter exposed. You see that in the testimony of the medical examiner. And she did clean up the victim and shave some parts so you could see those wounds. That's permissible under Haith. And Haith says that is a discretionary standard. This is a standard you're very familiar with. Would any reasonable judge acting consciously, do this? And I would suggest that this is very relevant to extreme atrocity and cruelty. And the defendant's argument in his reply brief goes only to deliberate premeditation. But this is an extreme atrocity and cruelty case because of the 26 shots and the 18 that actually hit.
Instructions?
I'm sorry?
Can I ask you about the instructions?
Absolutely.
The point that Mr. Shaw raises about the order, which I'm not sure you directly addressed, but the fact that the elements of first-degree murder get laid out, and as he said, I think the instruction is if you find the Commonwealth has proved beyond a reasonable doubt, 1, 2, 3, you should find the defendant guilty of first-degree murder. And then you get to what makes for provocation. So
I disagree that the judge says you should find first-degree murder. Nowhere in the model instruction, which is what was given in this case. And of course, it's the prior instruction. Nowhere does the judge tell the, he tells the jury the Commonwealth has the burden to prove beyond a reasonable doubt these elements. And if they prove those elements, that's first-degree murder. I mean, it doesn't say, I don't believe the language is you should. I was thumbing through them, but I would, at any rate, I rely on the model jury instructions. Now, just because this court has approved different instructions that then put that in the absence of mitigation as an element doesn't mean that all the prior cases that use the previous model are.
I'm wondering about whether
Right. So, your concern is noted, and it's always better to improve. So just because we've now improved with a new model doesn't mean the old model is bad. This court has approved the old model before, and the old model is good, but particularly here, in this case, there's no concern of the jury missing that they have to think about manslaughter, because you have the defense attorney saying this is a manslaughter, find him guilty, but guilty of no more than manslaughter. You have the prosecutor saying, no, manslaughter is not warranted here, here's why. And then you have the judge say, okay, I'm about to talk about murder. You have murder, first degree, these types, second degree, and voluntary manslaughter. I'll talk to you about that later. And then he references it again. And so he does it at the outset at transcript 9-175, prior to the murder instruction at transcript 9-176 to 177. And then it's the last thing, as in the model, it's the last thing that the jury gets before they get that highest degree of murder. So it suggests, sure, the defendant is saying the model instruction that uses an element, that says it should be an element, the absence, throughout all the murder instructions. That's one way to do it, but it's not the only way to do it. Nothing this court has ever said about instructions requires repetitive instructions of that nature. And it is sufficient to tell them, using it more as an affirmative defense at the end of the instruction. But here, the judge actually highlighted it. I'm going to be telling you about that. I'm going to tell you about it. Now I'm telling you about it. And I would also point out that in the model instruction that this court has just approved, that highest degree of murder is still in there. It uses different words. It says most serious offense, but it's still in there, and that, like this case, is the last word to the jury. So I would suggest this instruction is sufficient. It is a question of a substantial likelihood of a miscarriage of justice because there was no objection on this ground. And I would ask this court to find that the manslaughter instruction and the murder instruction that were given under the model that was used at the time are completely sufficient here. I do suggest that manslaughter wasn't warranted in this case. As we did at trial, we objected to the manslaughter instruction. The judge gave it, and he was saying, I don't want the case reversed, so I'm going to give it. And in this case, I would rely heavily on LeClaire. That's an engaged couple. But in that case, this court said those long-term suspicions are what cut off the manslaughter in this case. This was a close case on manslaughter, on whether that instruction should be given, and that's why the judge gave it. I would suggest it's not necessarily warranted here under the language in LeClaire and Rodriguez. However, you don't even need to reach that because the judge gave the model. He gave it out of caution to prevent reversal, and I suggest that it was sufficient in this case. And the jury had written instructions. There's no possibility that this jury was confused on this issue. It was argued to them. It was argued properly. That being the case, I would move just quickly to the prosecutor's argument on manslaughter. The defendant is suggesting that the prosecutor was saying the sudden revelation of infidelity is not sufficient to warrant a provocation, that the prosecutor was arguing that that law is no good, like you should ignore the judge thing. That is not what she was saying. What she was saying is, jury, as the conscience of the community in this day and age, would a person in the defendant's shoes, the objective standard, a reasonable person, be provoked here? Would a reasonable person reach for the Glock as opposed to reach for the phone or call a lawyer or do some more research on divorce or et cetera when they get that?
Or eat ice cream?
Or eat ice cream. Yeah. I mean, there's so many possibilities what you can do nowadays. Wouldn't a reasonable person move to one of those opportunities to avoid this kind of confrontation rather than kill their spouse just because of the sudden revelation of infidelity? And in that circumstance, she's not saying, don't pay attention to the law. She's saying, do your job as the conscience of the community. Does the evidence meet this objective standard that is required? And I would suggest to the court that's proper under the law, and and particularly in this case, where the defendant had known for so long that his wife was looking to get out, that she wanted an open marriage, that she'd suggested swinging, that they had discussed divorce, that he'd threatened to leave, that he'd called her a whore. This was going on, and I would suggest in this case that the prosecutor was well within her advocacy to stand there and say, in this day and age, does this revelation of infidelity get a reasonable person here? At any rate, it was unobjected to, and it certainly would not cause a substantial likelihood of a miscarriage of justice in this case, given the large amount of overkill in this case. I'd also like to point out one other thing. The defendant raises the claim that the bondage and unconventional sexual practices of the parties were inadmissible and that this court should find that they caused more prejudice than proof. And I would point to the defendant's record appendix at pages 60 to 62. The defendant moved in limine to allow the defendant to introduce evidence of the victim's sexual history regarding her and the defendant's proclivity for bondage. And then you'll also see he was trying to offer cartoons and comic statements about bondage and discipline, including I'm a bondage chick, happy tied up Tuesday. He wanted to offer these things as well. So the prosecutor wanted to offer them and the defendant wanted to offer them, and that's the way the judge took it when he viewed this in limine on the first or second day of trial. He said, I take it you both want it for different reasons. But he did his job under Commonwealth versus Carey. He was cautious in how he admitted it. He kept out some things and let in just testimony about those things like he's supposed to do. And in this case, they did an individual voir dire to make sure that none of the jurors who sat would be overwhelmed by this. So with a limiting instruction that it's only relevant to the nature of the relationship, the individual voir dire, and the judge parsing out what can go in, what can't, and the fact that the defendant wanted it as part of his trial strategy, I would suggest that Carey is satisfied and that should not cause reversal in this case. I am happy to answer any other questions that the defendant has raised or anything else on the record. If there are no other questions, I would ask this court to affirm the defendant's convictions for first-degree murder on both theories, deliberate premeditation and extreme atrocity and cruelty. The defendant's actions in this case of shooting the 26 rounds and hitting the victim 18 times, causing substantial damage to her body, show both his deliberate premeditation and the extreme atrocity and cruelty of this as their son was an infant who was sleeping inside their house. It is a tragedy, but it is a tragedy that requires this conviction of first-degree murder.
Thank you. All right.
All rise. Hear ye. All persons having anything further to do before the Honorable, the Justices of the Supreme Judicial Court, now sitting at Boston within and for the Commonwealth. At present depart, the sitting of this court is now adjourned. God save the Commonwealth of Massachusetts.